Picture this. You're standing at the airport, bags packed, ready to return home to America after visiting family abroad. You hand over your green card with confidence, but instead of a simple welcome back, the officer's expression changes. You're escorted to a secondary inspection room. Your heart races. What's happening? Could you actually lose your green card right here, right now? The answer might shock you, and what you don't know could cost you everything you've worked for. Stay with me because in the next few minutes I'm going to reveal the hidden traps that are catching green card holders off guard in 2026, and more importantly, how you can protect yourself. Welcome back to U.S. Immigration Intel, your trusted source for everything related to United States immigration and visa information. I'm your host, and if you're new here, make sure you hit that subscribe button and turn on notifications because we break down complex immigration topics into simple, actionable advice that could save your status. Today's topic is absolutely critical for anyone holding a green card or planning to get one. We're diving deep into airport detentions, deportation risks, and the dramatic changes that have come into effect in 2026. This isn't just theory or speculation. These are real situations happening to real people right now at airports across the United States, and you need to know what's going on. Let's start with a fundamental truth that many green card holders don't fully grasp. Your permanent resident status, while incredibly valuable, is not actually permanent in the absolute sense. It's conditional on you maintaining certain standards and following specific rules. The United States Customs and Border Protection, which everyone knows as CBP, has enormous authority at ports of entry. When you're coming back into the United States, you're technically applying for admission, even as a green card holder. This means CBP officers have the legal right to question you, inspect your documents, examine your belongings, and yes, detain you if they believe there's a problem with your admissibility. In 2026, we're seeing an unprecedented level of scrutiny at airports. The immigration enforcement apparatus has been significantly strengthened with better technology, more comprehensive databases, and stricter interpretation of immigration laws. What might have gotten a pass 5 or 10 years ago is now resulting in detention and potential removal proceedings. Let me break down the major categories of risk that are causing green card holders to face detention at airports. The number one issue, and this catches more people than almost anything else, is prolonged absence from the United States. Here's what you need to understand. When you receive your green card, you're expected to make the United States your permanent home, not a part-time home, not a place you visit occasionally, but your actual residence. The law presumes that if you've been outside the United States for more than 6 months, you may have abandoned your permanent resident status. Now, being gone for 6 months doesn't automatically mean you lose your green card, but it does trigger increased scrutiny. The CBP officer at the airport has the discretion to question whether you've truly maintained your residency. But here's where it gets really serious. If you've been outside the United States for more than 1 year without obtaining a re-entry permit, your green card is technically no longer valid for admission. Many people don't realize this. They think as long as the card itself hasn't expired, they can come and go as they please. That's absolutely wrong. The 1-year absence rule is a hard line in immigration law. When you show up at the airport after being gone for over a year, the CBP officer can refuse to admit you and require you to apply for a returning resident visa from abroad. In some cases, they might allow you to withdraw your application for admission, which means you voluntarily give up trying to enter, but your green card is essentially worthless at that point. I've seen heartbreaking cases where people went back to their home countries to care for sick parents, deal with family emergencies, or handle business matters, and they lost track of time. Maybe they thought a few extra months wouldn't matter, or they didn't understand the rules. When they arrive at the airport, they're shocked to find themselves in a secondary inspection room, being told they've abandoned their permanent residence. The officers will ask you to prove that you maintain ties to the United States during your absence. They want to see evidence like U.S. tax returns showing you filed taxes as a resident, property ownership documents, bank statements from U.S. accounts, employment letters, family ties in America, or anything else that demonstrates your intent to live permanently in the United States. If you can't provide convincing evidence, you could be placed in removal proceedings right there at the airport. Some people are given the option of signing a Form I-407, which is an abandonment of permanent resident status. If you sign this, you're voluntarily giving up your green card. Never sign anything without understanding what it means and, if possible, speaking to an immigration attorney first. Once you sign that form, reversing it is extremely difficult. The second major category that's causing detentions is criminal history. This is a complex and dangerous minefield for green card holders. Under U.S. immigration law, certain crimes make you deportable, even if you're a lawful permanent resident. These fall into categories like crimes involving moral turpitude, aggravated felonies, drug offenses, domestic violence, firearms violations, and others. What many people don't realize is that even misdemeanors can sometimes trigger immigration consequences. Let me give you some specific examples that are particularly relevant in 2026. Drug offenses are being scrutinized more heavily than ever. Here's something that confuses a lot of people. Marijuana is now legal in many U.S. states for recreational use and in even more states for medical use. However, marijuana remains illegal under federal law. Immigration law is federal law. This means that even if you legally purchased and used marijuana in a state like California, Colorado, or Washington, admitting to marijuana use or being caught with marijuana can make you inadmissible or deportable. CBP officers at airports have been specifically trained to ask questions about drug use, and many green card holders unknowingly admit to using marijuana, thinking it's no big deal because it's legal in their state. Wrong. That admission can be used against you in immigration proceedings. In 2026, we've also seen increased enforcement around domestic violence convictions. If you've been convicted of domestic violence, child abuse, stalking, or violating a protective order, these are serious red flags in immigration law. Even if you completed your sentence, paid your fines, and finished probation, the conviction remains on your record and can be grounds for deportation. When you return to the United States and CBP runs your name through their databases, these convictions pop up immediately. You'll be pulled into secondary inspection and officers will review the details of your case. Aggravated felonies are the most serious category. Despite the name, an aggravated felony in immigration law doesn't necessarily mean the crime was aggravated or even a felony under state law. Immigration law has its own definition. Crimes like theft, burglary, fraud, tax evasion of more than $10,000, certain drug trafficking offenses, and violent crimes can all be classified as aggravated felonies. If you're convicted of an aggravated felony, you're almost certainly deportable, and you have very limited options for relief. There's no statute of limitations on this. Even if your conviction was 10 or 20 years ago, it can still be used to deport you. The third major issue causing detentions is fraud and misrepresentation. The U.S. government takes honesty in immigration matters extremely seriously. If you lied on your green card application, failed to disclose important information, entered a fraudulent marriage, or misrepresented any material fact to obtain your permanent residency, that fraud can come back to haunt you years later. Modern database systems and information sharing between government agencies make it much easier to catch inconsistencies than it used to be. For example, let's say you got your green card through marriage, but the marriage was not genuine. Maybe you and your spouse got divorced shortly after you received your permanent residency. If USCIS investigates and determines the marriage was fraudulent, your green card can be revoked, no matter how long ago it happened. Or perhaps you claimed on your application that you had no criminal history, but in fact you had an arrest or conviction that you didn't disclose. Maybe you thought it didn't matter because the charges were dropped or it was a minor offense. In immigration law, you're required to disclose arrests even if they didn't result in convictions. Failing to disclose is considered misrepresentation. When CBP runs your information at the airport, sophisticated algorithms can flag discrepancies between your current information and what you previously submitted. Officers can pull up your entire immigration file digitally and compare it with other government records. If something doesn't match up, you're going to secondary inspection for further questioning. If the officer believes you committed fraud, you can be placed in removal proceedings. Another emerging issue in 2026 is the public charge ground of inadmissibility and deportability. The public charge rule has gone through many changes over the years, but the basic principle is that people who are likely to become primarily dependent on the government for support can be denied immigration benefits. If you've been receiving substantial public benefits like cash welfare, supplemental security income, long-term institutionalization at government expense, or in some interpretations, extensive use of Medicaid or food stamps, this could potentially be used against you. This is especially true if when you applied for your green card, you submitted an affidavit of support showing that you had financial resources or a sponsor, but then you immediately started relying heavily on public benefits. Immigration officers might argue that you misrepresented your financial situation or that you're now a public charge. Now let's talk about what actually happens if you're detained at the airport. First, you need to understand the difference between primary inspection and secondary inspection. Primary inspection is the quick check that most travelers go through. You hand over your passport and green card. The officer scans them, asks a few basic questions like where you've been and why, and you're on your way. Secondary inspection is very different. This is where you're taken to a separate area for more detailed examination. Being sent to secondary inspection doesn't automatically mean you're in serious trouble. Sometimes it's random. Sometimes there's a minor issue with your documents that needs clarification. Or sometimes the system has flagged something that turns out to be a mistake. However, if there's a genuine concern about your admissibility, secondary inspection is where it will be addressed. You could be there for hours. Officers will ask detailed questions about your travel, your activities abroad, your ties to the United States, your criminal history, and anything else relevant to your case. They may search your electronic devices, including your phone and laptop. They have broad authority to do this at the border. If the officers determine there's a serious problem, several things can happen. You might be given the option to withdraw your application for admission. This means you voluntarily agree not to enter the United States and you return to where you came from. If you do this, you're not formally deported, but your green card may no longer be valid for future entry. You might be issued a notice to appear, which is the charging document that starts removal proceedings. This means you'll have to go before an immigration judge to defend your right to keep your green card. In some cases, particularly with criminal issues, you might actually be detained and held in immigration custody pending your hearing. You might also be offered what's called expedited removal if the issue is fraud or misrepresentation. Expedited removal is a fast-track deportation process with very limited rights to appeal, or as I mentioned earlier, you might be asked to sign Form I-407, abandoning your permanent resident status. This is often presented as the easy way out, but it has permanent consequences. Once you abandon your green card, getting another one requires starting the entire immigration process from scratch, which could take years and may not even be possible depending on your circumstances. So what are your rights if you're detained at an airport? First and foremost, you have the right to speak to an attorney. However, and this is important, you don't have the right to a free attorney in immigration matters. You can consult with a lawyer, but you'll have to pay for it yourself. And practically speaking, it may be difficult to reach an attorney while you're detained at the airport. You have the right to remain silent. Although refusing to answer CBP's questions can result in you being denied entry, you do not have to consent to a search of your electronic devices, but refusing can also result in your devices being held or you being denied entry. It's a difficult position to be in. My advice is to always be polite and cooperative with CBP officers, but also be very careful about what you say. Don't lie, because that will only make things worse, but don't volunteer information unnecessarily. Answer questions directly and briefly. If you're asked about criminal history, be honest. If you're asked about your time abroad, explain truthfully. If you have documentation that supports your case, provide it. Things like tax returns, employment letters, property deeds, and family information can all help demonstrate your continued ties to the United States. Let me give you some practical prevention strategies to avoid these problems in the first place. If you know you need to be outside the United States for more than 6 months, apply for a re-entry permit before you leave. This permit allows you to stay abroad for up to 2 years without being presumed to have abandoned your residence. The application must be filed while you're in the United States, and you need to be in the U.S. for your biometrics appointment, but after that, you can leave while the application is pending. Always file your U.S. taxes every year, even if you're living abroad temporarily. This is one of the strongest pieces of evidence that you maintain your residence in the United States. Keep your U.S. driver's license current. Maintain U.S. bank accounts, and if possible, keep property in the United States. These all show ongoing ties. If you have any criminal issues, consult with an immigration attorney before you travel internationally. Some convictions absolutely make you deportable, but others might be waivable or defensible depending on the specific circumstances. An attorney can review your case and advise you on the risks. Be extremely cautious about admitting to drug use, even marijuana. If CBP asks you at the airport if you've ever used drugs, understand that this is not a casual conversation. Your answer is being documented and can have serious immigration consequences. Never lie, but you have the right to decline to answer questions that might incriminate you. Though, as I mentioned, this can result in denial of entry. Keep detailed records of your travel. Know exactly when you left the United States and when you returned. If you travel frequently, keep a log. This helps if there are ever questions about whether you've maintained your residence. If you're traveling to countries that the U.S. government considers concerning from a security perspective, such as Iran, Syria, North Korea, or certain others, be prepared for additional scrutiny when you return. Have a clear, legitimate explanation for why you traveled there. The landscape of immigration enforcement in 2026 has changed significantly. Technology has advanced, databases are more comprehensive, and there's less discretion being exercised in favor of permanent residents who have violated the rules. What might have been forgiven or overlooked in the past is now resulting in detention and deportation. The key is to be proactive, understand the rules, and never take your green card for granted. If you're currently outside the United States and you're worried that you might have a problem when you return, consider consulting with an immigration attorney before you travel back. They can review your situation and help you prepare. In some cases, it might be better to apply for a returning resident visa from abroad, rather than showing up at the airport and hoping for the best. Remember, once you're in removal proceedings, your options become much more limited and expensive. It's far better to avoid problems in the first place than to try to fix them after the fact. Your green card represents years of effort, significant investment, and your dreams for life in America. Don't lose it through carelessness or lack of knowledge. That brings us to the end of today's deep dive into airport detentions and deportation risks for green card holders in 2026. I hope this information has been valuable and eye-opening. If you found this helpful, please give this video a thumbs up, share it with anyone who might need this information, and definitely subscribe to U.S. Immigration Intel if you haven't already. We're committed to bringing you the most current, accurate, and practical immigration information to help you navigate the complex U.S. immigration system. Drop your questions in the comments below, and I'll do my best to point you in the right direction. Remember, knowledge is power, especially when it comes to protecting your immigration status. Stay informed, stay prepared, and stay safe. This is U.S. Immigration Intel, and I'll see you in the next video.